Thank you very much, Victor, for your introduction. First of all, I'd like to say that I'm very happy to be here with you in this meeting, even if we cannot meet in person. What's important is that after many months exchanging proposals, posters, materials per email, that we have managed to get together and to share the preliminary stages of a research and to share our ideas and share our work with you. So far, I think this is a very fruitful experiment. I'm really enjoying it. I've enjoyed the presentations of colleagues before me, and I will try to take good note of some of the presentations and some of the questions that you have raised. I'd also like to say that all of this would not be possible without the commitment of our host and colleague, Blanca Rodriguez, because when she gets into a project, she devotes herself, body and soul to it. And this is a very interesting project, and this Congress that is happening in the framework of this R&D project, which is the principal investigator. Well, she's very kind to invite us, and me in particular. What am I going to discuss? I will very briefly present an overview of how in the Spanish system, how we tutor gender identity. And we will go back to the idea of discrimination because of gender identity. The jurisprudence and the law do not sufficiently cover this topic. Sometimes they are confusing. The topic of gender identity is confusing in the way it is discussed. If you compare it with the anthropological or the scientific approaches that were discussed before, from the point of view of the law, and particularly in Spain, we have limited protection. I don't want to speak about categories again, because this was a bit conflictual when we used it, the categories that we have, and the law are limited. First, from a constitutional perspective, this is something that somebody already mentioned. I think it was Blanca at the beginning who said that we usually see the tutelage of people in terms of gender identity is linked to the recognition that a constitution includes, and also international law, of the respect to human life and full development of each person's personality. And this is the legal framework that we use for the social order and peace. So the right to have your own sexual identity is an expression of your personal identity, and it's therefore part of personality as a legal concept. This is also seen in the recognition of some fundamental rights, the right to intimacy, Article 18, Article 15, the article in terms of the protection to your health, in Article 43 of our Spanish Constitution. Also regarding equality in front of the law and non-discrimination, that is included in Article 13, and I will be developing this in a minute with the sentence of the Constitutional Court. Even if it's not explicitly mentioned in the Constitution, with the other reasons that we have that describe reasons for discrimination, and that we have seen historically in these documents, such as birth, race, origin, they are explicitly included in Article 14. Transgenderism would also be included implicitly in the cases for discrimination historically, and it would be therefore granted special protection against discrimination. In line with this, and in the same sense, we also have a protection of gender identity with a constitutional provision in Article 9.12 in the Constitution that forces political powers to work for equality. And that is definitely a task of public powers, that is to work to achieve the full participation of transsexuals, the speaker is saying, individuals as a category of people that are specifically vulnerable. We're not speaking about rights, but another important aspect that we should mention is Article 10.0 of the Constitution, discussing the need to interpret fundamental rights in agreement with international treaties signed by Spain. This is an interesting point because we do have an array of treaties that have developed these concepts internationally, and the protection of gender identity is binding for Spain, as we will see in a minute. And the Spanish law, the public institutions in Spain have to comply with these provisions and the rights introduced in international law and also in EU legislation. This is the general framework, and we can see how, therefore, there is gender identity as protected in the Constitution, but then we have to see how this is translated into the law. Right now, the legislation and at state level, because we know that in Spain we also have a regional legislation, but at state level, this plurality of rights that is linked to the legal recognition of gender identity, despite the fact that there are some rights acknowledged, does not, in Spain, there is no integrated law for gender identity. However, there are specific standards regulating aspects that have to do with transsexual individuals in different areas, civil law, labor law, health, etc. In particular, they also gather standards against discrimination for these reasons in the health environment. We see that this is a especially sensitive area for this topic, because from a traditional perspective, we've always linked this reality to surgery for sex change in a biological sense. These interventions and the intervention in sex were depenalized in 1983 in Law 1/3, as this reform of the criminal code excludes these interventions from criminal acts. So this is a recognition of the rights of transsexuals in the health space. We have Law 33/2011 that prescribes the following. If a person has the right to have their interventions in situations of equality without discrimination due to origin, birth, religion, opinion, age, disability, sexual orientation, disease, or any other personal circumstance or social circumstance. This public health law thus incorporates specifically the elimination of discrimination in health. So it equates, it uses the same kind of a description of Article 14, but it also includes gender identity as a reason for discrimination, independent of sexual orientation or sex itself. if we move to another topic, if we go to labor law, even though we have several standards that work against discrimination to sexual reasons or gender identity, Article 4 of the Statute of Workers, different acts, or Article 8 of the Social Sanction Act. The truth is that only Law 33/2012 of social standards, and it's the most recent one, explicitly mentions sexual identity as a reason for discrimination. Article 96.1 of this Act sets forth that the load of evidence will be decreased if there are foundations to claim discrimination due to sexual orientation, gender identity, or similar actions. This Act on Social Conditions is a clear example of what I mentioned at the beginning when I mentioned Article 10.1 of the Constitution, in which we see how EU law has an effect on the legal protection of transsexuals in Spain, because this is the outcome of the transposition of a EU directive of the European Parliament and the Council in terms of equal opportunities at work, explaining specifically that the field of the scope of equal treatment cannot be just applied to the discrimination in terms of belonging to one sex or the other, as it has been done in the past. But in order to comply with its object and the scope of the directive, it has to be also applied to the discrimination that happens due to sex change in a person. And they introduce other measures whenever there's discrimination due to gender identity. And this is what is transposed in state level law. If we move to another area in criminal law, we also have protection in the criminal code against acts, damaging acts that may attack them in their gender identity. And the reform of the Criminal Act of Law 5/2010 included and those events contemplated in Article 22, those crimes committed because of sexual identity, regardless of the sex or gender, which are also reasons. And the modification in terms of hate crimes, the hate crimes law, also includes the position of special vulnerability as sexual identity, and it makes a difference between that and sex, gender, and sexual orientation. These are the situation we have scattered in the legislation, and they have to do with the tutelage that the state offers to the identity of the person. Apart from this, we do not have an act that agglutinates a regulation, but we do have an act in civil law that might be more significant in practical terms, but also and mainly due to the symbolic meaning that it has. That is Act 3/20, 17 of 15th March, regulating the modification of sex in registries. So this regulates when a person in the civil register wants to change their name and also their sex in the registry and for the national ID. So this is what assigns one sex or the other, and therefore to be entitled to certain things. What happened before 2007, before this act was approved? Well, in order to change the name and sex of a person in the registry could only happen if there was a sentence in a court of law authorizing this. Apart from that, the most prevalent case law was in the High Court, and they valued chromosome or gonad criteria rather than psychosocial criteria. What does that mean? That they demanded from the courts, in order to authorize that change, they demanded that this person had to go through the sex reassignment surgery. So this is a legal gap. We really have to look at things individually by the courts. And also, even if there was a trend in case law to move in that direction, but it changed after 2007, sometimes we saw sentences that were diverging. In 2001, there was an attempt to change the situation, and the socialist group in the Senate presented a bill to regulate the registration of transsexual individuals. This was approved, but it was not passed as an act. In line with what Assunta was saying, when she was speaking about activism of transsexuals and transgenders, I remember that recently we had with us in another course organized by our colleague Rosario Naranjo, we had Carla Antonelli. She's a politician and activist and was one of the people who pushed for the approval of this act. She was one of the first people, or the first in Madrid, who managed to change her identity in the registry. And she also threatened the Socialist Party to go on hunger strike if they didn't pass this law. Apart from these anecdotes, we can say that in the next legislature, that's when they passed this act in 2007. What does the law states in a nutshell? And I think that what's more interesting, first, Article 1 claims that the person entitled to require this change in the registry is any Spanish national of age and with enough capacity to request it. This on the one hand, and then Article 4 of this act, what it regulates are the requirements that are needed for this change to happen. And this is mainly two. First, that the person, that the applicant has been diagnosed with gender dysphoria. So we have to accredit this through a medical or psychological report that has to mention that there is a dissonance between the morphological gender inscribed initially and the gender identity felt by the person, and also the persistence of this dissonance. So this is what we understand as gender dysphoria. Apart from that, this report has to state that there aren't any personality disorders that could have an impact on this dissonance. Apart from that we have this report claiming that there is gender dysphoria and that there is no personality disorder. They also have to accredit, in order for this to be authorized, that the person, the applicant, has been treated medically for at least 2 years in order to accommodate their physical features to the sex they claim to be. On the one hand, the position that's still introduced in this law in 2007 to change the registry is highly biologicist and even pathologizing. So this is not seen as a right for self-determination of your gender, but it is a step forward in some sense if you compare it with what we were doing before. On the one hand, because the law itself sets forth that it won't be needed in order to authorize the registration, the change, the surgery is not necessary, and it also exempts applicants from presenting that certificate of medical treatment in those cases where there are age or health reasons that hinder this, and whenever we have a medical certificate claiming that the situation is thus. So the requirements are relaxed and the legal interpretation has been quite loose. What the law says is that the change in the registry will be applicable as soon as the change is approved. So this person will have all the rights inherent to the new situation. What happens with this law? It has been criticized from different perspectives, especially due to its incapacity to respond in a satisfactory manner to the social condition that they're trying to regulate. As we've heard, the gender identity of a person implies far more than just rectifying a registry, and it requires the tutelage of other things that are not included in this law. For example, healthcare of transsexual individuals, the existence of a right to their own identity, gender identity and sexual identity. On the other hand, another interesting aspect in the law, we're still looking at things in a binary way. We do not even contemplate the possibility of non-binary identities. So it's not there, it's just there to regulate something very specific. On the other hand, there are also, of course, they do not require sex reassignment surgery, but the requirements still imply the pathologization of gender identity. This is not seen as a right. And then there's another problematic topic. I will be devoting a few minutes to it because Blanca also mentioned this at the beginning. And there was a ruling by the Constitutional Court, which has to do with the lack of specific provisions in the law regarding the situation of minors. Article 1.1 of the Act recognizes legitimization of applicants, that recognizes the applicants as Spanish nationals of age and with sufficient capacity to apply. So this article of the law in particular is seen as unconstitutional, and the Supreme Court submitted it to the Constitutional Court, saying that in the sentence 99/2019 rules over this as unconstitutional, and this claim was presented due to different appeals presented by the parents of a minor, and as legal guardians, they have requested the change of the name and sex of the child when they were 12. They didn't obtain a favorable response from the civil registry. They took that to the courts, to the regular courts, and they were supported by the Constitutional Court. They submitted appeals to the Supreme Court. The Supreme Court takes the questioning of these parents regarding the constitutionality of Article 1.1 of that Act 3/2007, and the Constitutional Court considers whether this article, by denying the possibility and the legitimacy to apply for this change for minors, would go against Article 15 in the Constitution, the right to intimacy and health. So all this is seen in the framework of the freedom to have to your personality and the right to your personality in Article 1 of the Constitution. What does the Constitutional Court say? They recognize that to a certain extent, so the sentence is a bit ambiguous or confusing, but they recognize that this is unconstitutional. And it's, whereas the Constitutional Court says that this affects the right to your personality, and they say that if this act is to focus on the free development of the personality, this is limited if it is only applicable to those who are of age, as the Act claims in Article 1. This condition deprives this right to minors in terms of the decision over their own identity. The Constitutional Court says that it also affects intimate life because the lack of access to the sex, the sign of birth, and that received by a person is one of the most relevant features that a person must have a right to have acknowledged by others. So these things are affected by the provisions included in the Act of 2007, and they conclude that Article 1.1 of Act 3/2007, as it requires to be of age to change the details in the register without another individual pathway for minors who are mature enough, then it is not constitutional, as they do not have any alternative for minors. So this is a legal measure that constrains constitutional rights in a disproportionate way, as this is over the tutelage needs for minors. So it declares it as unconstitutional. The sentence is a bit confusing because it claims this is unconstitutional, and there is an individual vote by Encarnación Rocafría, and I agree with her because this sentence declares that this is unconstitutional, but it only includes minors who are mature enough and who are in a stable situation of transsexuality. So it seems that they initially they only considered people of age to access that change is only reproachable whenever it affects minors who are in a stable situation of a transition. Another question that was also presented by the claimants, but it was not accepted, was Article 4 of the law that has to do with medical treatment prior to the request for at least 2 years. As they understood that this was a pathologization of transsexuality and linked to the need for medical treatment. This question was not included. The High Court thinks that this is not applicable here. But, as somebody I think mentioned before, and as we will see in the coming days, we do have a question open to the constitutional and social debate, There's Article 4, but this is not sent to the Constitutional Court anyway, because it was stopped by the High Court. On the other hand, if we look, Paula, I'm sorry, but I have to show you the yellow card. The coordinator is telling me that you are going above the time allocated. Okay, so I'll just mention, what do I have, 2 minutes? Yes, 2 minutes. Okay, so briefly, I'll just mention another sentence that is of 2008. It's not so recent, but it is also very interesting because they speak about discrimination against transsexuals. This is 165/2008, and it goes, it responds to an appeal of the father of a minor who had modified the visitation regime of the father to the child, limiting it when the father starts a process of gender reassignment. And the father presents a complaint saying that he's being discriminated due to sex as he's transsexual. This is what the claimant presents, that they have changed the visitation rights, and that behind this is discrimination against a transsexual person. The Constitutional Court does not rule in favor, because the argument was questionable, says the emotional instability of the father caused by the sex change process is affecting the psychological stability of the minor, and therefore they have to sacrifice this right of the father for the right of the child. But then they claim that this has nothing to do with the situation of the father's transition. And this brings it back to regular courts. But the sentence is quite controversial, but I'm not going to go into details because they've already told me I have to go back to it. And this is what is included. This is important because it includes transsexuality as one of the issues included in Article 14. The Constitutional Court responds in the sense I mentioned before. This is that the discriminatory rights of Article 14 is an open list. It's not a closed list. And therefore, the Constitution, with it, what it tries to do is to establish the interdiction of several forms of discrimination, especially against groups at a disadvantage and that go against the dignity of people. And it concludes its reasoning by saying that even though the situation of the transsexuals are not mentioned in Article 14, it is, of course, seen in this situation, historical situation, etc., what I said before. Because it is obvious that transsexuals are at a disadvantage. There is no problem in acknowledging that this is another reason that is protected under Article 14, but after that, the Constitutional Court, and the rest of their arguments, they make a mess. I don't understand why they agree to this first, they acknowledge this first, but they do not use this opportunity to clearly define transsexuality as a reason to discriminate against a person and as a matter in itself. And then there's a contradiction, and they confuse it with sexual orientation, and the sentence then speaks about sexual orientation, where we're speaking about, obviously, as we all know, we know that this is a different concept. I will write the sentence numbers 178, 2008, I think. So finally is the European Court of Human Rights. who has to protect the plaintiff, the claimant, because they have to go to the ECHR, and though the European Court of Human Rights accepts the position of the Constitutional Court, they call them out because they have confused sexual orientation and gender identity.
Laura,
So they tell them,
ahora intervengo yo. Ya
Laura, I'm sorry, you have to finish.
Se nos va, es que se nos acaba la sesión.
Otherwise, we will have to close the session. Okay.
La intérprete tiene que hablar ahora y tenemos un poco de tiempo de debatir.
And we have to listen to Anna and have some time for the discussion. Okay, just to conclude. So there's lack of a clear definition and an insufficient legal framework at national level for gender identity, and lack of case law also to develop this and to interpret these aspects. And that's it. I'm sorry.